Hey everyone, and welcome back to my channel. If this is your first time, I'm Jennifer Etherton, the founder of Moonlight Mobile Notary here in Fishers, Indiana. In my last estate planning video, we reviewed living trusts and how they may be a good option for your estate plan. This week we are continuing the estate planning series and discussing powers of attorney. This will be broken down into two videos because there's a lot of information to cover. This week we will discuss the different types of powers of attorney available and what they can accomplish. Powers of attorney are a notary's bread and butter. There are as many reasons to have a power of attorney as there are people who need them. They are also an integral part of any successful estate plan. Let's start with what a power of attorney is and the different types that are available. A power of attorney is a legal document giving one person the power to act for another person. The power given to this person, also known as the agent or attorney in fact, can be broad or limited based on the situation. One of the most common reasons for a power of attorney is an individual becomes ill or disabled. While on the other end of the spectrum, a power of attorney can be limited to a single transaction, such as an individual can't be available to sign legal documents for a financial transaction. I see this a lot when working with real estate closings. One thing to remember about powers of attorney is that they can be revoked by the person who has them created, also called the principal. A few other ways for a power of attorney to end is if the principal dies, the courts invalidate it. In the case of a divorce where the spouse is named as the agent, or the named agent can no longer carry out the duties. Some powers of attorney will lapse when the principal becomes incapacitated, but others, such as a durable power of attorney, will stay in effect. It's not only important to understand the different types of power of attorney and what authority they can bestow on the agent, it's also vital to understand your state laws when it comes to this part of your estate plan. Each state is different, so it's important to understand the correct format and wording required to ensure your power of attorney is valid. As with the entire estate planning series, I will be discussing the types of powers of attorney that are recognized in the United States. Different countries have different requirements and it's impossible to be an expert on all of them. No matter what country you live in, it's best to check with legal counsel before you put one in place. What are the different powers of attorney and how can each of them improve an estate plan? The first is a general power of attorney. This can be considered a financial power of attorney. This allows the principal to give his or her agent the power over the financial side of their life. This includes opening or closing financial accounts, managing the principal's personal finances, buying or selling assets or property, and even filing taxes. This comes in handy when the principal is either too busy or unable to take care of their day-to-day finances. This is more of a band-aid than a permanent solution because the general power of attorney terminates when the principal becomes incapacitated, decides to revoke it, or passes away. This is more to help a friend or family member who doesn't want the hassle of dealing with their own finances but is still considered competent. The next form of power of attorney is the limited or the special power of attorney. This is also quite common during real estate closings. There is usually a limited power of attorney present in the closing documents, giving a financial institution the power to correct small errors such as typos or grammatical errors, but the signers have to be consulted if bigger issues are discovered. This type of limited power of attorney will expire after so many days, and the financial institution will have to consult the signer on any error after the time lapses. Limited powers of attorney can also be set for a single transaction or a certain portion of the principal's financial affairs, such as giving a broker the power to oversee a retirement account. The next level of power of attorney is the durable power of attorney. This one has more teeth to it. If the durable power of attorney is put in place, then if the principal becomes mentally incapacitated, the power of attorney stays in place. Under the durable power of attorney, the agent is still able to pay the principal's medical bills and look after his or her finances, even after the principal is not able to participate. This type of durable power of attorney doesn't allow the agent to make medical decisions on behalf of the principal. This is strictly for their financial well-being. In order to help with medical decisions, a separate healthcare power of attorney is needed, and it also can be a durable power of attorney. In some states, a durable healthcare power of attorney is called a healthcare proxy, and it outlines the principal's consent to give the agent power of attorney privileges in the event of an unfortunate medical condition. This makes the agent legally bound to oversee medical care decisions on behalf of the principal. There are times when a durable financial power of attorney and a durable medical power of attorney is contained in a single document, but it is highly recommended for these two powers of attorney to remain separate. This will help eliminate inappropriate conflicts of interest. It is best that the agent for financial affairs cannot access your medical information and vice versa for your medical agent. This is a good way to have a checks and balances for your affairs. The last major type of power of attorney is the spring power of attorney. This document defines exact circumstances that should occur before your power of attorney springs into effect. This is a bit of a safeguard since it outlines the exact level of incapacitation that needs to be reached before your agent can take over. We will go over the exact steps to get a power of attorney in place and the decisions that need to be made on Wednesday's video. For now, we are concentrating on the broad strokes of power of attorneys. Now that we have covered the basics, let's go over the pitfalls and things to avoid, or at least consider before having a power of attorney drawn up. Choosing the right agent is the key to the entire process. This is not a step to be taken lightly. In the event of a medical power of attorney, you are giving your agent the power of life and death. On the other end of the spectrum, you are giving your agent a blank check to manage your finances. The key is to appoint one agent for your finances and one agent for your medical decisions. Both of these individuals need to be trustworthy and capable. It's vital that the individuals you choose possess both qualities, so you know your wishes and intentions are followed. The reason for this is the agent you choose has the same legal authority that you do. In a sense, they become you when they oversee your affairs. With these warnings out of the way, your agent can be any competent adult you choose. This can be a friend, family member, or a professional such as an attorney or an accountant. Even your personal banker can hold your power of attorney. The choice is completely yours. The most common agent chosen is a spouse or an adult child. Both of these are good options if the individual meets the trustworthy and capable criteria. In this instance, the adult child is usually the better choice because they are younger and more likely to still be competent when they have to perform their duties. A spouse is not usually the best choice simply because most couples are relatively close in age. This can eliminate the spouse if he or she becomes incapacitated around the same time as the principal. Since naming an adult child is usually the best option, the problem comes when there is more than one child to choose from, or in this case, two children, since you need one agent for your finances and one for your medical decisions. The best thing to do is play to each child's strengths. You need to evaluate the trustworthiness of each child and determine who has the best intentions. Also, factor in the reliability of each child. You can even split the duties and have more than one power of attorney, especially when it comes to finances. For example, if you have a child that is a whiz in the markets and understands investments back to front, then put him or her in charge of your retirement and other portfolios, while another child could be the best choice for day-to-day matters such as paying the light bill or running the family business. If there are more than two responsible children, the third could be in charge of medical decisions. This way your children will be required to work together, but each is responsible for the part that best fits their personality and abilities. No matter how you decide to split the responsibilities, it is important to make sure each child understands that you are wanting to work within their abilities and it's not a personal slight to anyone. There can be hard feelings if one child feels left out, so it's important to be delicate. We have gone over the benefits of having a power of attorney and how one can help you when you are not able to take care of your own affairs. Now it is time to talk about the risk. I have touched on this a little bit, but it is important to make the right decisions. A power of attorney gives your agent a lot of power, and if you choose the wrong one, it's a license to steal and bleed you dry. There are ways to keep yourself safe even if you are incapacitated. One way is to put a provision in your power of attorney that forces your agent to account for his or her actions. Your attorney can easily include this type of clause in your power of attorney. This is a method of trust but verify. It is best if your agent is required to give reports to an independent third party. This can be your attorney or accountant. While this might seem like a pain, it helps keep your agent honest and can also create a paper trail. One lighter example is if a family member believes your agent is being dishonest. If your agent has submitted reports of their actions, this can allow the independent third party to investigate and either prove or disprove any malfeasance. It can also protect an honest agent from false accusations. I understand I have given you a lot to think about, and I hope I haven't scared anyone away from the idea of having a power of attorney. They really are one of the best ways to protect yourself while you are still alive, but unable to handle your own affairs. Having a good power of attorney as part of a larger estate plan will allow you to have peace of mind, knowing you have the right people to help you when the time comes. On Wednesday, we will continue the discussion on powers of attorney and the roadmap to having one drawn up. We will also go over some tips and tricks to convincing aging parents to put one in place. We still have a lot of information to cover, and I hope you will join me for the conclusion. If you found this video informative and would like to know more about real estate, estate planning, the notary world, or adulting, please hit the subscribe button and don't forget the notification bell. And if you enjoyed this video, give it a thumbs up. I hope you have a great beginning to your week, and I will see you on Wednesday.